All right, settle down. Absolute silence, please. Welcome, KSLU law students, to today's masterclass. I want your undivided attention. Today, we are going to thoroughly dissect Question 20, discuss the tortious and contractual liability of the state. Make no mistake, students, this is a guaranteed 16-mark question for your final semester examinations. If you follow my instructions today, if you apply the exact case laws and structure your answer precisely as we discuss, you will secure top marks. Take out your notebooks and your pens. Let us begin.
Here is your synopsis. 1. Introduction to State Liability. 2. Part 1. Contractual Liability. 3. Part 2. Tortious Liability. 4. Sovereign versus non-sovereign functions. 5. Landmark case laws breakdown. And 6. Conclusion and present position. Replicate these exact 6 headings on the very first page of your exam booklet. You want to immediately establish structural clarity for the evaluator.
Write down heading number 1, Introduction to State Liability.
Write this down exactly as you see it. The Constitution of India recognizes that the state can be held liable like any private individual. Liability is mainly divided into 1. Contractual liability and 2. Tortious liability. Now listen carefully. Modern constitutionalism dictates that the state is simply not above the law. Framing the state as a quote-unquote private individual for the purposes of liability, that is the golden thread of your entire answer. You must make the examiner understand that when the government enters into a contract or commits a civil wrong, it strips off its sovereign crown and it stands in the court just like you or me.
Heading number 2, Part 1, Contractual Liability. Underline Part 1 in your booklets to clearly demarcate the structural shift.
Pay very close attention to this provision. Constitutional provision, Article 299. Contracts made in the exercise of executive power must be expressed in the name of the president or governor and be executed by authorized persons. Now, citing Article 299 correctly is absolutely mandatory to fetch marks here. If you write an entire answer on contractual liability and you forget Article 299, you have completely failed to grasp the Bare Act provision. Do not make that mistake.
Let us break that Bare Act down into the absolute essentials. 1. It must be in writing. 2. It must be in the name of the president or the governor. 3. It must be executed by an authorized person. Listing these essentials of a valid government contract numerically on your page demonstrates absolute conceptual clarity to the KSLU examiner. You don't write this as a messy, rambling paragraph. You write it strictly as a checklist.
And what exactly happens if you ignore the checklist? If these conditions are not fulfilled, the contract is void. Notice the text, not voidable, void. Emphasize the absolute nature of the word void in your scripts. This explains the strict legal consequence of bypassing Article 299. The government cannot and will not be bound by informal or verbal promises.
However, if those conditions are strictly met, then the state is liable for breach of contract. It can be sued like a private person. Contractual liability in India is very well settled. Once a valid contract under Article 299 is formed, the government operates squarely on the principles of standard contract law. They absolutely cannot hide behind state power to escape a bad bargain.
Now, you must substantiate this with authority. Case, State of Bihar versus Abdul Majid. I instruct you to draw a physical box around this citation in your exam script. This captures the evaluator's attention immediately and proves that you have actually done your reading.
The text clearly states the government can be sued for breach of contract. But you cannot just write one sentence. You must provide the deep dive breakdown. What are the facts? A sub-inspector of police was dismissed from service for cowardice. Later, his dismissal was found to be ultra-virus, meaning illegal, and he was reinstated. He then sued the government for his arrears of salary. The government tried to argue using the Old English rule that civil servants hold office purely at the pleasure of the crown and cannot sue for salary. Well, the Supreme Court of India flatly rejected this, the final ratio decidendi. The rule of English law does not apply in India in this context. The state is liable to pay the arrears of salary. The relevance here is absolutely profound, students. It cements the contractual liability of the state to its own employees, proving that legitimate financial claims against the government will be upheld by our courts.
Let's move on. Heading number 3, Part 2, Tortious Liability.
Read the definition carefully. Meaning, tortious liability means liability of the state for wrongful acts or torts committed by its servants. Now, I must warn you, tortious liability is far more complex than contractual liability. It requires a very careful, nuanced explanation in your exams. This brings in the concept of vicarious liability. If a government servant, acting during their course of employment, acts negligently and harms a citizen, who pays? The servant or the master, which is the state.
Note this quote, "The king can do no wrong." This is the historical English doctrine. Under Old English common law, the crown simply could not be sued in tort. But in your exam, you must explicitly write. In India, this rule is not absolute. You must show the examiner that you fully understand our constitutional departure from outdated English common law immunities.
Which brings us to heading number 4, sovereign versus non-sovereign functions. Look at this strict comparison. Sovereign functions include defense, law and order, administration of justice. The result? State is not liable. Versus non-sovereign functions, which include commercial or welfare activities. The result here? State is liable. This, students, is the most critical conceptual juncture of your tortious liability answer. This is exactly where evaluators look for absolute precision. I strongly advise you to draw a similar comparative T-chart right there in your exam booklets. It will secure top marks by visually highlighting the distinction before you even write your explanatory paragraphs.
Heading number 5, landmark case laws breakdown. This section is the battleground where a 10-mark answer transforms into a 16-mark answer. The first case, P&O Steam Navigation Co. v. Secretary of State. Underline this heavily. It is the foundational, pre-independence bedrock case for this entire topic, decided way back in 1861. The P&O ratio officially distinguished between sovereign and non-sovereign functions, establishing that commercial acts are liable. Let us do the mandatory deep dive. The facts. A servant of the plaintiff was driving a horse-drawn carriage. Due to the sheer negligence of government workmen at a government dockyard, a heavy piece of iron fell, the horses were startled, and the plaintiff's horse was injured. The plaintiff sued the Secretary of State for India. Chief Justice Peacock delivered the crucial ratio decidendi. He split the acts of the East India Company into two. He ruled that maintaining a dockyard is a commercial act, a non-sovereign function that any private entity could do. Therefore, the state was held liable. The absolute relevance of this case is that it birthed the very dichotomy of sovereign versus non-sovereign functions in Indian legal jurisprudence. You must make that clear to the evaluator.
Next, write down State of Rajasthan v. Vidyawati. Label this strictly in your margins as the prime post-independence example of non-sovereign liability.
Note the verdict. State held liable for negligence as it was a non-sovereign function. The facts here are tragic but legally essential for you to master. A government jeep owned by the state of Rajasthan and driven by a government employee was returning from a repair workshop. The driver drove rashly and knocked down a pedestrian, Vidyawati's husband, who unfortunately later died. Vidyawati sued for compensation. The state tried to claim sovereign immunity. The Supreme Court totally rejected this. The ratio decidendi, driving a jeep back from a repair shop, is not a sovereign function. It is a routine, non-sovereign act. The court held the state vicariously liable. Explain to the examiner that the relevance of Vidyawati is its absolute proof of welfare state accountability. The Supreme Court explicitly stated that in a modern welfare state, the government simply cannot endlessly hide behind the archaic shield of sovereign immunity. But you must present balanced legal knowledge. You cannot only cite cases where the state lost. You must cite Kasturi Lal v. State of Uttar Pradesh. Pronounce this case authoritatively in your mind as you write it down. This is the contrasting authority you must present to show balanced legal knowledge and secure those final marks.
The text here is critical. State not liable for acts done in a sovereign function. Let's execute the deep dive. The facts. Kasturi Lal, a jeweler, was arrested by the police on suspicion of possessing stolen gold. His gold was seized and kept in the police malkhana, the custody room. A police head constable misappropriated the gold and absconded to Pakistan. Kasturi Lal sued the state of UP for the return of the gold or its value. The Supreme Court, relying on the old P&O steam navigation principle, delivered a very harsh verdict. The ratio? The power to arrest, search, and seize property is a statutory power strictly delegated to police officers. It is a core sovereign function. Therefore, despite the gross negligence of the state machinery, the state of Uttar Pradesh was protected by sovereign immunity and held not liable. The relevance here is to show the examiner you truly understand the harsh reality and the strict boundaries of sovereign immunity when statutory police powers are involved. Finally, heading number 6, conclusion and present position. A legal answer without a concluding analysis is incomplete. Students, do not skip this. Read the final points.
The state is liable in both contractual and tortious matters, subject to limitations. Contractual liability is well defined under Article 299. Tortious liability depends on the sovereign versus non-sovereign distinction. Modern law favors greater accountability and justice. In summary, you must urge the evaluator to see the bigger picture. Write a strong concluding paragraph. Leave them with this provocative thought. If modern law indeed favors greater accountability, and India is truly a modern welfare state, should the archaic shield of sovereign immunity continue to protect the government when innocent citizens suffer at the hands of state negligence? Indian courts are progressively shrinking this immunity to uphold justice. Structure your answer exactly this way, support it with these detailed case analyses, and you will absolutely conquer this 16-mark question. Best of luck with your KSLU examinations. Class dismissed.